So it's 2024 and millions of gun owners just woke up potentially as felons because of a complete rifle and magazine ban. So let's talk about what is happening. But real quick before we jump into this video, if you think these rifle and magazine bans are clearly a violation of the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to thank one of the new sponsors of this channel, which is First Form. Now, at a couple videos back, I talked about how First Form is now a sponsor of the channel because I've been kind of on a weight loss journey. I know a lot of you guys have mentioned in videos that, it looks like I'm losing weight, and obviously I am. I did the 75 hard program. First Form was a big part of that, me using their supplements. A lot of the guys that work at First Form actually watch this channel, and so they jumped on the channel wanting to support what we do here for the 2A cause. You can check out some of their supplements using the links down below, both in the description section and the pinned comment. Also, you can check them out by going to firstform.com/armscholar, and that will take you directly to their website where you can check out some of their supplements. But regardless, thank you so much for First Form for sponsoring this channel and supporting this freedom content. So like I mentioned in the intro, in this video, we're going to be breaking down how millions of law-abiding Americans just woke up in 2024 potentially as felons simply because they own rifle and magazines. Millions of people in Illinois now face serious criminal convictions because the Seventh Circuit decided to directly defy what the Supreme Court said in their rulings, and even worse, the Supreme Court of the United States itself has been unwilling to hold these lower courts accountable for their direct defiance. Recently, we received news from the Supreme Court that they denied 2 emergency injunctions, which were asking for the Supreme Court to put a temporary halt on the state of Illinois' wide-reaching rifle and magazine ban. The Supreme Court was asked multiple times to put a halt on this law, which was taking effect in 2024. However, the Supreme Court decided to not do that. Now, those 2 cases are the Colkins v. Pritzker case and then also the NAGR v. Naperville case. These cases involved a challenge to the Protect Illinois Community Act, or PICA, which places unconstitutional restrictions on rifles and magazines and does a lot of other things as well. PICA also requires a registration requirement, which is required to grandfather in those firearms that you already possess. And again, that registration deadline period has closed now starting in 2024. So as of 2024, there are no longer the ability to register these firearms that you have prior owned lawfully, legally possessed, and now all of a sudden your possession of those items is illegal and opens you up to serious criminal penalties. So we need to talk about what happened in these cases and what is set to happen going forward in these challenges to PICA. In Colkins, that case was originally brought in an Illinois state lower court who on review entered summary judgment against the state of Illinois, declaring this ban unconstitutional for denying equal protections under the law. So that was a win in an Illinois state lower court. The state court found that the rights to bear arms under the state and federal constitutions are fundamental rights. Therefore, the challenged legislation was subject to strict scrutiny, which the legislation did not satisfy. Therefore, the state lower court ruled that PICA was void and unconstitutional. Now, in response to losing that case, the state of Illinois appealed that decision up to the Illinois State Supreme Court. And on review, the Illinois State Supreme Court reversed the lower court's decision. In that case, there was a specific concern also about contributions to 2 of those Illinois State Supreme Court judges who potentially received millions of dollars from defendants who are directly involved in the case, including the governor of Illinois, and then also some of his representatives and some of the defendants' attorneys who were involved in the case. Now, after that decision in the Illinois State Supreme Court, the plaintiffs then filed a writ of cert to the U.S. Supreme Court, seeking the U.S. Supreme Court to review this case. And in response, the U.S. Supreme Court accepted that waiver and then set the case to be heard on conference. It's going to conference. It was distributed, and that is taking place on January 5th, so later this week. Now, in the meantime, in the Colkins case, the plaintiffs also filed an additional emergency stay request pending Supreme Court review by Justice Barrett. So an emergency stay request was sought by Justice Barrett. And what that means is that on top of the traditional writ filed in Colkins, they also filed for an emergency stay request to Justice Barrett for her or the full court to issue a stay on PICA at least until the U.S. Supreme Court got together and heard the Colkins case on January 5th. Well, recently we received an order from Justice Barrett which simply states that Colkins' application denied by Justice Barrett. So that was it. It was just a plain and just blanket denial of the Colkins application. So that emergency stay request was denied by Justice Barrett and did not go to a full court vote. Now, the second case that was denied an emergency request was the NAGR v. Naperville case. The Supreme Court there decided also not to grant emergency relief in that case. The NAGR lawsuit was a little bit different in its posture because although they sought emergency review from the Supreme Court, they sought an emergency injunction. They also still had a en banc petition pending in the Seventh Circuit. However, the Seventh Circuit also denied en banc review of that case. They actually denied review of a multitude of cases that were seeking Seventh Circuit en banc review. So not only did the Seventh Circuit deny review in multiple PIC Act lawsuits, they decided to not review any of these rifle and magazine ban cases, but then you also had the U.S. Supreme Court also deny review in the NAGR lawsuit and then the Colkins case as well. Again, recently received an order from that court, the U.S. Supreme Court, denying emergency injunction and that emergency relief. The order from the Supreme Court simply reads that NAGR application for a writ of injunction pending certiorari presented to Justice Barrett and by her referred to the court is denied. Now, interestingly, with this denial, and really all these denials, is we don't see any dissents. The Colkins case didn't go to a full court review. And then also here in this NAGR application, there are no dissents even by Justice Thomas, which is curious. NAGR, however, still has plenty of options. The main one that they're likely going to engage in is file an actual Supreme Court writ, especially now that the Seventh Circuit en banc panel has denied review in their case. But keep in mind, even with the NAGR case, this would still be an interlocutory review by the U.S. Supreme Court. Simply, this would be a review of whether or not the preliminary injunction should have been granted by the lower court. So there would not be a final merits review of this case. Now, Colkins is a little bit different because that was, I believe, issued on a summary judgment motion. The state Supreme Court, you also reviewed the summary judgment, which is a final merits decision. So any review by the U.S. Supreme Court would be a final merits review. So that's also why Colkins is a little bit more important and why I'm focusing a little bit more on Colkins. Now, the last thing we discussed with this whole Illinois PIC Act battle was the fact that there was one last-ditched kind of Hail Mary in the lower courts in front of Judge McGlinn, which is one of the lower court judges that did prior issue a favorable preliminary injunction. Now, what was asked was for Judge McGlinn to issue a new preliminary injunction, kind of circumventing the Seventh Circuit panel's review, kind of circumventing what the Supreme Court did with the recent denials, and that was in the FFL v. Pritzker case. However, the judge there, Judge McGlinn, did deny, in fact, that new injunction request. He then said because of the higher court's precedent, his hands were kind of tied because of what the Seventh Circuit had done and also what the Supreme Court recently did with their denials. His hands were tied. He had to punt this issue. However, he did say that he was going to expedite review of this case to the merits portion of the review. So at least in the FFL v. Pritzker case, it's going to proceed forward at the lower court level on a final merits review, potentially on expedited review. So after all that back and forth with lower courts, appellate courts, the U.S. Supreme Court, what has now happened is that millions of gun owners in Illinois are now potentially exposed under this new rifle and magazine ban to serious criminal penalties because of their simple possession of magazines and rifles, and also because of that registration process and deadline that is now up. There is no longer an ability to register these rifles because that registration period has ended. Now, the one thing still with a kind of silver lining and hope in this type of issue is the fact that the Colkins case is still set for Supreme Court conference, which is set to happen this week on January 5th. Now, when it comes to the Supreme Court conferences, there are a few things that can happen. First, at the conference, the justices will get together, review the case, and decide whether or not they want to actually grant review to the case and want to hear oral arguments on this issue. I believe it only takes about 4 justices to grant review in the case, so you need 4 of the justices on the U.S. Supreme Court to grant cert to this case. However, I will state that when it comes to the U.S. Supreme Court, they have been very inactive as of late. The Supreme Court generally only grants review to a fraction of the cases that are even presented to them. And traditionally, in kind of the past, the U.S. Supreme Court would take about, I believe, 150 to 160 cases per year. However, this specific Supreme Court, I believe, is averaging only about 65 cases a year, which is not good at all. Not only is that not good for the 2A cases, they've been very inactive when it comes to 2A cases, but just in general, they have not been very active. They are not taking enough cases. So even at this conference, there is a high probability that they will deny review. Also, they could simply just punt the conference, punt the case to a later date, which also happens quite often. So really just not a good situation for those people in Illinois. And I suspect going into 2024, we will see even more states try to implement these types of restrictions. We will see more statewide rifle and magazine bans pop up. And right now, because of the inactivity of circuit courts like the 7th Circuit, 9th Circuit, And also because of the inactivity of the Supreme Court, this stuff is going to continue to happen. So not good news for those in Illinois, but I want to make you guys aware of what's going on, especially for those who maybe are not aware at all. If anything else changes, if anything else develops, especially with the conference this week, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of doing news. But as always, thank you guys for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.